Hello and welcome to another video by Financial Earning. Today I want to share a little bit about the Marion auto contract with Mullen Automotive. So there's been a little bit of confusion in terms of exactly when Mullen gets paid, and we're going to go over a lot of that in this video. But we're going to start from the top. This is a firm order agreement between Mullen Automotive and Marion Isuzu LLC, DBA Marion Mullen. Again, I'm not a financial advisor. This is for entertainment purposes only. Just want to go ahead and get that out there now. But let's go ahead and get started into some of these recitals. So, buyer wishes to purchase from Mullen, and Mullen desires to manufacture and sell to buyer a total of not less than 6,000 units of the initial production of 6,800 units, which would be the first order requirement of the vehicles manufactured and produced by Mullen. Going down to subsection III. Mullen shall deliver the vehicles at buyer's cost to the street address for delivery specified in the applicable purchase order. Mullen's standard lead time on purchase orders of vehicles is 4 months after a purchase order is accepted by Mullen unless otherwise specifically agreed to in writing. So buyer shall issue a purchase order contemporaneous with the execution of this agreement for 1,000 vehicles. Buyer shall issue another purchase order on or before May 1st for no less than 1,000 vehicles. All additional purchase orders required to fulfill the first order requirement, which is that 6,800 vehicles, shall be issued no later than August 1st, 2023. Mullen will use its best efforts to fill each purchase order presented by buyer and accepted by Mullen. And then I want to go into a little bit of details. If Mullen shall not be liable for delay or failure to deliver vehicles where such a delay or failure to deliver is the result of any event beyond the reasonable control of Mullen, including but not limited to any law or regulation of government entity, act of God, fire, flood, earthquake, storm, epidemic, quarantine, restriction, war, insurrection or riot, civil unrest, freight, embargo, car wreck, delay or shortage in transportation, unusually severe weather, or inability to obtain necessary labor, materials, fuel, energy, or manufacturing facilities due to such causes. So key thing there I wanted to highlight is the materials. So we know that Mullen Automotive had some sourcing delays in terms of their airbags and some chips. That's been communicated throughout this last year. Mullen did get that sourcing issue taken care of, and they were able to get those first vans delivered to Marion Auto before the end of 2023. Let's go ahead and keep going down. Mullen shall not sell any vehicles to any person or entity that is not an authorized Mullen dealer. So the way that this firm order agreement is written, it doesn't say that Mullen can't sell vehicles to any other dealer. They just have to be an authorized Mullen dealer. So I want to put that out clearly. There has been some discussions saying that Mullen can only sell to Marion, and that's just not the case. Again, payment terms, patches of title. Payment for each vehicle is due in full upon delivery. So every time Mullen says that there's been a delivery made, an invoice, that payment is due immediately. There's no waiting for a customer to pay the dealer or anything like that. Mullen's getting paid right when they deliver that vehicle. And as you saw near the top portion, Mullen shall deliver vehicles at buyer's cost to the street address for delivery specified in the applicable purchase order. So again, if there's any kind of transportation cost, anything of that nature that does not get reduced or subtracted from the actual sale of the vehicle. So what Mullen has there as revenue is the full revenue. Okay. Terms and termination. This agreement shall have a term commencing on the effective date and continuing until the earlier of the following. Either the first order requirement is satisfied, which is that 6,800 vehicles, or December 31st, 2023. So the terms of this actual agreement did expire on December 31st, 2023. So we're going to go into a little bit more details as we keep reading on. But there's been some discussions back and forth saying, well, you know, if Mullen doesn't have all the vehicles completed, or if there's less than 500 miles on the vehicle, then technically the dealer can turn around and get a refund. Well, let me ask you this. If this term is expired on December 31st, 2023, would that mean that all the information in this specific firm order agreement no longer applies? Because if that's the case, then all the vehicles that have been sold to Marion Auto and invoiced and revenue provided to Mullen would be that. There would be no refunds. So let's just go ahead and keep going down a little bit further. I got one more slide I want to talk about. But let's keep going. Other Mullen terms of sale. The other terms of sale, which is the next slide we're going to talk about, applicable to the vehicles are attached here too as Exhibit C and considered an integral part of this agreement. In the event any conflict, the express terms of this agreement, excluding the terms of sale, which is that Exhibit C, shall control over any conflicting item or provision in the terms of sale. All right, so before we get to Exhibit C, I did want to talk a little bit about Section 9, which says repurchase of vehicles. So dealer will endeavor to the extent practicable, considering all relevant factors to sale and deliver all Mullen products and services that are ordered by the dealer. At dealer's discretion, any new product less than 500 miles not sold by dealer after a period of 12 months can be returned to Mullen at original pricing. Any new, unused, never titled, undamaged vehicles with less than 500 miles, then unsold in buyer's inventory, the prices of such vehicles shall be the same as those at which they were originally purchased by buyer, less all prior refunds or other allowances, if any, made by Mullen to buyer with respect thereto. So again, if this term is expired, then this repurchase of vehicles portion of the term would no longer be applicable. If you want to say that they can be refunded, then we have to say that the purchase order that is currently ongoing between Mullen and Marion Auto would still be applicable. So let's talk a little bit about Exhibit C. So termination. No order may be canceled or altered by purchaser except upon terms and conditions applicable to seller and seller's sole discretion, as evidenced in writing by seller's authorized representative. In bold, no order may be canceled after the products that are the subject of the order have entered into production. All right, talk about delivery again. It's a little bit of a repeat, but it's part of terms of sale, so I just wanted to reiterate this. So seller will arrange for shipment of all products to the point designed by purchaser. All vehicles shall be shipped FOB Mullen factory. Purchaser shall pay for seller's transportation costs as invoiced. So there you go. All right, delay in delivery of any installment shall not relieve purchaser of its obligation to accept remaining deliveries. Seller shall not be liable for any losses or damages as a result of any delay or failure to deliver due to any cause beyond seller's reasonable control, including but not limited to any act of God, epidemic, act of purchaser, embargo, or other governmental act, regulation, or request. Fire, explosion, flood, hurricane, accident, strike, slowdown, war, act of terrorism, riot, delay in transportation, equipment failure, inability to obtain necessary labor, equipment, materials, again, materials, that was the biggest delay previously, or manufacturing facilities, or failure of usual sources of supply or usual modes of transportation. In the event of any such delay, the date of delivery shall be extended for a period equal to the time lost because of the delay. Purchaser's exclusive remedy for other delays and for seller's inability to deliver for any reason shall be rescission of the underlying order. So basically, if none of the following apply, then the purchaser, the remedy for the purchaser would be a rescission of the underlying order. But we do know that the materials were delayed due to sourcing concerns with airbags and chips. So that is part of this clause. All right, and payment and title. Again, purchaser or its financing company that has been designed to seller by purchaser in writing shall pay seller for vehicle products, COD, cash on delivery. So again, want to reiterate the fact that if Mullen has delivered the vehicles, they have been paid for. They will show up in the Q1, fiscal year 24 Q1, which ended December 31st. And again, the last thing I wanted to highlight in blue, all shipments shall be separately invoiced and paid for without regard to subsequent deliveries. So thanks for letting me break down this contract a little bit. I hope it helped explain a little bit to you. I'm interested to see if there's going to be any news in terms of Marion and Mullen, creating a new terms for this contract, or maybe amending this term. I think it'd be interesting to see and kind of give us a little bit of clarity. If you like this video, please go ahead and like and subscribe and leave a comment. Let me know what you did like. Let me know what you like a little bit clarity on. And I look forward to giving you guys all a new video. And welcome to 2024. Thanks.